Good morning. Welcome to the Courtroom Files Live. Starting just a couple minutes early today, we'll go ahead and start with Judge Simpson today.
So what are you going to say first? Having you wait.
Your name, sir?
John.
Thank you. You're requesting an adjournment?
Yes, Your Honor.
Couple weeks will work, or?
Yes, sir.
All right. Without objection, probable cause conference, April 10th, 2025, 9 a.m. Found in these matters will continue.
Thank you, John.
Thank you.
Your Honor, could I have one request before?
Certainly.
I know we had last week phone call issues, phone calls were closed. And I'm still listening to the calls and we'll file a motion if appropriate. Mr. Lee is wondering if he's able to at least call his mother instead of having all of his calls restricted. If that's possible to work out.
Any response?
Your Honor, we would have a strong objection that he was mailing letters to his mother to get in contact with people.
And I recall all of that, so I'm going to deny that request.
Yes, Your Honor.
Court does call the case People versus Larzell, Washington.
Good morning, Edward Rubix on behalf.
Okay, Jim,
I'm requesting an adjournment to get a benefit.
are you? Your client would request it if they were here. What a concept.
You're right.
Yeah. A week would be enough? Yeah, okay. Bench warrant will issue for defendant failure to appear. Bond is set in the amount of 10,000. Cash surety, that warrant will issue immediately. Thank you. We still have nothing from him. Well, did they sign him out? They did.
Yeah.
Okay. Court does call the cases of the People versus Tyve Mills. 3 cases.
And your children preparing on behalf of the people.
On all 3.
Yes, correct.
Counsel approach.
While Judge Simpson's muted, let's go over to Fulton County, Georgia, where they're working through an all-purpose docket this morning.
Days, credit for time served 32 days, balance suspended. You're to have no violent contact with any of the members of the Fulton County staff, including those working at the jail. Do you understand? Do you understand?
Yes, ma'am.
On the battery charge, your sentence is going to be 12 months to serve 90 days, credit for time served 26 days. You have 19 days to serve out before you report to probation. Once you've completed the 19 days, you will report to probation on the first available Monday, Tuesday, or Thursday. This will be, of course, subject to any other holds you have at the jail. Once released, don't forget to report to probation, and then you will enroll in a 12-week anger management program. You must enroll within 30 days of being released. At all times, you're to have no contact with Leonia Owens. You have to stay 200 yards away from her. You cannot live with her. You cannot talk to her, speak with her in person or through any kind of electronic device. And if you violate that condition, you could end up back in jail.
Yeah, can I say something? That was not Fulton County, that was ACDC officers. That wasn't Fulton County.
Mr. Blitz, please don't say anything.
Okay.
If you have any violent contact with any law enforcement from whichever agency they represent on this entire planet, you'll be back in jail. Does that make it easier?
Yes, ma'am.
All right.
Okay.
Next case, please.
Next, Your Honor, we can go to position number 1, Mr. Barnes.
Mondrell Barnes is accused of criminal trespass from December 21st, 2024. His accusation number is 24 CR 8262G. Mr. Barnes, you've been advised of your rights and your attorney is Ms. McLeod. Ms. McLeod, how are we proceeding?
This is a negotiated plea this morning, Your Honor.
All right, any discrepancy with the jail time?
No, Your Honor.
All right. Mr. Barnes, please raise your right hand for the plea. Do you solemnly swear and affirm that testimony you provide will be the truth to the best of your knowledge? You need to say yes or no. Repeat.
Yes, ma'am.
Ms. Folk?
Yes, Your Honor. The state's recommendation is 12 months served 26 days, credit for time served 13 days. That's going to be from December 21st, 2024 to December 24th, 2024 and March 19th, 2025 until today. Balance suspended, stay away from 187 Maury Avenue. That's Moury in Atlanta, Georgia. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
We so stipulate, Your Honor.
Mr. Barnes, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take this plea offer today?
No, ma'am.
If you decide to plead guilty to this charge, you would have to give up your right to a trial. You will not be able to go back to court to face your accuser, challenge the evidence brought against you, and have the state prove the charge beyond a reasonable doubt. Are you prepared to give up this right? Are you prepared to give up your rights?
Yes, ma'am.
How do you plead to one count of criminal trespass at 187 Maury Avenue?
Guilty.
His sentence is 12 months to serve 26 days, credit for time served 13 days, balance suspended. Stay away from that location, otherwise we get to do this all over again. Thank you.
Thank you, Your Honor.
Let's go back to Judge Simpson. He has unclicked his mute button.
Mr. Jerkis, you're requesting an adjournment also on Mr. Supes? Yes. All right. Yes. Hold on one moment. So how much time, there's a referral that has gone over to 14B. I presume you're tagging along with that. So where is it in that process?
I would just ask for 2 to 3 weeks, Your Honor. Mr. Ray hasn't met with Mr. Stoops yet, but said that it's on soon. So I don't know for sure if he had been answered within 2 weeks, but I would ask for 2 to 3 weeks.
All right. Why don't we do the April 17th,
Thank you, Your Honor.
2025, 9 a.m. Yes, as to bond.
Your Honor, it's come to our attention that he has made 51 calls since his arraignment to the victims. He's been calling his phone when it is the victim that answers. In talking, they use a code name calling her Aunt Diane, but it's the victim. So we would have concerns that he's contacting her by using his own phone number and that's his phone privilege.
With regard to that, I haven't heard anything to do with this.
Any response to that?
No,
You're
Your Honor,
presuming
I
it's not on your
think
case.
So, yes, I would.
Well, you'll be entitled to certainly file a hearing once you hear all of the calls, but at this point, I'm going to revoke the defendant's phone privileges. His bond in each of these cases will continue.
Thank you, Your Honor.
You know what? When I I call you, I'm gonna use a code name. Yeah, no, I'm gonna do that. I think because that'll work. That's the case. People versus Joseph Hamby.
Good morning, Your Honor. Victoria Burton here as Chief Assistant Prosecutor appearing on behalf of the people.
Good morning.
Stephanie Cannon on behalf of Mr. Handy, WAC 24F1-1672.
And Cheryl Foster Tucker on behalf of Joseph Hamby in the case ending at 9.
Sorry, can you take this record?
All right. On your case, you're waiving.
Yes.
What are we doing on the other case?
Yeah, we're gonna set that one for a preliminary exam.
All right. So let's set, discovery is complete on that case.
Yes, Your Honor, to the best of my knowledge.
Would the people have their witnesses available on the 8th?
I see no reason why we wouldn't, Your Honor.
All right. Preliminary examination in that matter will be set in person, April 8th, 2025, 9 a.m. That is before Judge Falvo. In that matter, bond will continue.
Thank you so much, Your Honor.
Thank you. In the other matter, sir, you're waiving your right to a preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. All right. You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution. All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Go on.
Wait formal reading, standing charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
1:30 before Judge Hamud.
May 19, 2025, 1:30, Judge Hamud.
Thank you, Your Honor.
Thank you. Bond continue.
Thank you, Your Honor. One of my
Thank
staff
you.
can find that information. Papa Childers.
Yeah,
assistant-
they're all like all out of control here, Ms. Burton Harris. So we'll see if we can track one down. It's been something this morning.
Doing their best, Judge.
All right. Thank you. Court calls.
All right, good morning, everybody. Welcome again to the Courtroom Files Live. I've got eyes on 8 different courtrooms at the moment. As is our normal fashion here, we'll skip around as I see fit, as interesting things happen, but we'll go ahead and continue to ride with Judge Simpson for the moment.
John Andrews.
All right. Good morning.
Your Honor, please take the time to set the probable cause conference. We will be waiving preliminary hearing at this time. I believe you should have your sign.
I do. So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 through 4 with 5 and 6. Mr. Allen.
Yes, Your Honor, and we would waive any formal reading and standing.
Defendant having waived formal reading, standing mute as to all counts, court will enter a not guilty plea. Pretrial will be set for
April 9th at 1:30 before Judge Conlon.
April 9th, 2025, 1:30, Judge Conlon. Bond will continue.
Thank you, Your Honor.
Thank you.
Have a great day.
You do the same. Mr. Braxton, can you talk back to me now? I don't know what's going on. Mr. Braxton, if you can hear me, wave your hand. Now, this is even worse because I'm getting nothing now.
Yeah.
I'm not getting a response at all. I think that's frozen. Yeah, we're gonna have to. We'll try to get it through. I don't know. Court calls the case People versus Isaiah Levy.
Good morning, Your Honor. Victoria Burton here as Chief Assistant Prosecutor appearing on behalf of the people.
And good morning, Your Honor, to the staff and people on the report. Mohammed Nasser, P7445, attorney on behalf of Mr. Isaiah Levy. With your standing to my right, sir, state your name for the record. Isaiah Levy.
Thank you. What are we doing?
Judge, may I please report, I I didn't realize the attorney's records would be the deputy chief. I didn't have a chance to speak to her. We did receive discovery yesterday. However, your staff did advise me that we failed to file the substitution attorney. I'll do so immediately. I'd like to set this for a new PCC so I can speak to the prosecutor in regards to a resolution. I'll wait the 14, 21-day rule, Judge.
Probable cause conference, April 10th, 2025, 9 a.m.
Thank you so much, Judge.
Thank you.
Have a good day.
Bound continue. Court calls case People versus Christopher Willis.
Andrew Childers, bring on behalf of the people.
Edward Roots on behalf of Christopher Willis. Your Honor, may I approach the prosecutor?
You may.
Okay, well, he's muted a second. I want to take a minute and point something out. Yesterday, during the live stream, we had an interaction in Judge Fleischer's court where there was a woman who was being held, if you'll recall, on a fugitive case. She was wanted out of Pennsylvania. It was alleged a $750,000 theft situation, but she was also the one who was a brand new mother. The baby was only weeks old, and they were having problems in the court. They were discussing in the court where she was having problems being allowed to breastfeed and all of that. I promised I'd go back and put something together on that because I had recognized her. I'd seen her in Judge Fleischer's court a couple of days prior. I wanted to let you know that I did that. When we're done with the live stream today, if you go to the Courtroom Files channel, you will find a video there on that whole situation where the entire situation is better played out than what we saw in the live stream. So I want to make you aware that that existed. Judge Simpson is still muted. Let's go back to Fulton County, Georgia, where they continue to work through the all-purpose calendar.
You would have to give up your right to a trial. You will not go back to a courtroom to face a judge or a jury. You will not be able to challenge the evidence that will be brought against you in a court of law. You will not be able to confront your accusers. Your attorney will not be able to present your arguments and your defenses, and the prosecutor will not have to prove the charge against you beyond a reasonable doubt. These are your constitutional rights that you would have to give up if you decide to plead guilty to battery family violence. Are you prepared to give up these rights?
Ma'am, Mrs. Law.
I don't understand your response.
Yes, ma'am, Mrs. Law. Yes, ma'am. Yes, ma'am.
If, how do you plead to one count of battery family violence from June 15th, 2024?
Guilty.
Your sentence is going to be 12 months to serve 150 days, credit for time served 58 days. Based on the calculations we have, you have an additional 17 days. Your release date will be set by the sheriff of Fulton County, who manages the jail where you are currently in. Based on what I have, it appears that you will either be released on April 14th or April 15th, but that will be dependent upon the sheriff of Fulton County. Once you have completed your jail time, and if you have no other cases holding you at the jail, you will then report to probation within 48 hours of being released, and you must report on the first Monday, Tuesday, or Thursday, as I said, within 48 hours of being released. While you are on probation, you will complete a domestic violence intervention program, and you will enroll in that program within 30 days of being released. And you will attend and complete all 26 classes without missing or skipping any of them, and you will pay for those classes out of your own pocket. You'll also be required to do 40 hours of community service at any nonprofit agency, but it cannot be a church and it cannot be a school. You will do your community service at a minimum rate of 5 hours per month, beginning with the first month. At all times while you're on probation, you are to have no contact with Michaela Castile. You're to stay 200 yards away from her and not communicate with her in any way, form, or manner. You're to stay 200 yards away from the entire Piedmont high-rise apartment complex located at 3601 Piedmont Road in Atlanta, Georgia. You're not allowed to enter that entire complex, including the parking lot, the leasing office, or any of its private property. Your probation will continue until the remainder of your 12 months are completed, and you must be up to date with your probation fees. Thank you.
Thank you, Your Honor.
Next, Your Honor.
All right, we can go back to Judge Simpson now.
He moved. Mr. Braxton, can you hear me?
I can hear you now.
Okay, now we can hear you too. All right, they got us straight, I think. I'm gonna call that case. People recall, court recalls case, People State of Michigan versus Braxton.
Andrew Childers, attorney on behalf of the people.
Morning again, Your Honor. Please assume before David Burtis on the Department of Corrections, who's again appearing to from the Michigan Department of Corrections.
All right, and I think we had gotten to the point where I'd apprised you of the charges and you understood the charges you're pleading to, correct, sir?
Correct.
And you understand that because of count 2 is a victim's rights case, I can't do immediate sentencing. So you understand that?
I do understand that.
Okay, very good. So, sir, to the charge of attempted possession of a firearm in a motor vehicle, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
I do.
You understand you're giving up your right to appeal of right?
Yes, I do.
Are you on probation or parole?
No, I'm not.
Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
I am.
And because you believe that you're guilty of these offenses?
Yes, sir.
April 4th, 2023, at the location of 2861 International Drive, Ypsilanti Township, Washtenaw County, State of Michigan. Were you in a motor vehicle?
I was.
Did you have possession of a firearm while you were in that vehicle?
There was a gun in the car. Yes, sir.
Okay. And did you know it was in the car?
Yeah.
Yes. Okay. Thank you.
Yes.
And you didn't have any authority to carry that weapon in that fashion, did you, sir?
No, sir.
All right. You at some point came into contact with police?
I did.
Probably didn't go well. What happened?
I tried to run.
Oh. That didn't work.
No, sir.
You knew they were trying to arrest you?
Yes.
All right. Counsel? All right. Court will accept the defendant's plea of guilty to counts 5 and 6. Counts 1, 2, 3, and 4 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this case will be May 1st, 2025. What time? 10 a.m. before Judge Washington.
Okay.
All right.
All right.
Bond will continue. All right. All right. Thank you. Take care of yourself, Mr. Braxton.
All right. Take care.
Okay, let me cut in here for just a minute if I may. So Haunted House 2012 just posed a question in the chat. Who's the most respected judge within the pool of judges that you feature? I don't have an answer to that. So I want to open it up to the wisdom of the crowd. Do me a favor, get in the chat and let us know who you think is the most respected judge. To To be honest with you, I like them all for different reasons. Judge Simpson here, I respect him because I believe he's an honest man. Judge Fleischer, I really like because of the fact that he's not afraid to flesh things out and admit what he doesn't know and go find answers and stuff like that. Judge Shackelford, who I've been monitoring this morning, I like her because she's not afraid to tell you what she thinks. I like Judge Middleton because of the respect for the community that he's in. I like Judge McNally because he's no nonsense. So there's a lot of ways to answer that, but let us know your thoughts. Who do you like and why? Go ahead and put it in the chat. Let's have a discussion. Back to Judge.
Will not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right in both cases.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count in the case ending 1101 and on count 1 with 2 following in the other matter. Ms. Cannon.
Thank you, Your Honor. We would like to read the information standing on the charges.
Defendant in every way, form, or reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
April 7th at 1:30 before Judge.
April 7th, 2025, 1:30 before Judge Hamoud.
Thank you, Your Honor.
Thank you.
Thank you. Bond will continue.
Thank you.
Does call the cases of the people versus Beverly Boss. They need to sign off.
This is public defender Natalie. Probably went and on behalf of Ms. Boss, who should be dialed into Zoom here. She called the public defender's office this morning. She talked to several of the legal assistants. She's actually sick and she was having trouble logging onto the Zoom, but I believe she was finally able to successfully dial in. If she's using her father's phone, the last 3 numbers would be 238.
Nope. I have one call in. Could
I'm
be.
not sure if that's the number she's using. If it's her father's phone, it would be that number.
Ms. Boss, if you called in on Zoom, I only have one number, but if you called in on Zoom, you'll need to hit *6 on your phone to unmute.
Hello?
Oh, hello, what's your name?
Hello. Beverly Boss?
Oh, that's her.
Awesome, thank you.
Yes, that's me.
So, Your Honor, I have discussed this matter with people. I was planning, Ms. Boss and I have not been successful in having a phone conversation prior to today. I was going to give her an update this morning, but obviously was unable to be accomplished. I would ask her one week. Wow. I understand if 2 weeks.
It's gonna be 2 weeks.
I understand, Your Honor. Thank you.
Nice try, though.
Your Honor, no objection, but I do want to inquire about mine.
Oh, boy. Probable cause conference, April 10th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, so Ms. Boss, as the court is likely aware of the nature of the case, has a longstanding history with, I think, multiple substances, including alcohol. One of these is an OWI case. I think it's her. As one of these counts relates to the.
No, I don't. I don't have an OWI.
It isn't. I'm sorry. One of these counts relates to the removal of a scram tether for such a case. I am inquiring if she is currently on an order. I saw that when she was arraigned on these cases, that I didn't see a community corrections order for her. So given the nature, I think, of the charge, I want to make sure she says it.
Ma'am, are you?
Hello?
Are you on a scram tether?
I was on a scram tether and I had, and a long time ago, and something had, I thought it was in the cases with what we are going through now. It was a part of the bond too. I bonded out on the cases.
Okay, but are you on a scram tether right now?
No, I'm not on any kind of tether.
I believe that is correct, Your Honor.
that she was not on a scram tether or under order to be on a scram tether, my understanding.
Okay, so how's somebody get out for tampering with a device and then not get put back on the device if that were?
So that was on
I'm
another
sorry
case.
for being too logical. Yeah, go ahead.
So that was for another case that she was on probation for in circuit court. Then allegedly something happened with that scram tether, which then the charge initiated. She has been on bond in both these cases for some time, previously referred for competency, was at the forensic center, was found incompetent but restorable, has been restored, it's now it's a finding of competency. That being said, I don't believe she was ever under any order in either of these cases, to my knowledge, to be on a scram tether. And none of the charges in either of these cases are an OWI. Or
So, but
Yeah, that don't make sense. I did a year in the county jail. I got raped, my tether cut off. And then I did 365 days, turned around, did another 6 months. And then they pulled up charges on me for tampering with my tampering device. But me and my lawyer and the safe house with the other judge, I think it was non-prejudice to come back at me with the tether tampering. So all of a sudden, they just
okay. I got it. I'm not going to change anything. I'm just going to leave it where it is because I see the dates, and so bond will continue.
Thank you, Your Honor.
What was the date, Your Honor?
Yes, ma'am.
What was the date again? April what? 9th
10th.
or 10th?
April 10th.
9 o'clock.
2 weeks from today.
Okay, thank you, sir.
Thank
you,
you.
Your Honor.
Thank you, Your Honor. Thank you, Ms. Boss. We'll be in touch again.
Okay, thank you.
Court calls the cases of the people versus Elijah Craft.
And then we have the people, Your Honor. Morning, Your Honor. Lord Daddy, Assistant Public Defender, with on behalf of Mr. Kraft, who is approaching. Oh my gosh.
I know, every week.
Every week.
I know.
don't know what it is.
Well,
In both matters. Mr. Kraft, could you say your name to the board?
what are we doing?
Your Honor, we have discovery in one matter, but not in the second matter. So the case that is ending in 0342, we have media discovery that's missing with reference to the police report. I'm hoping that the APA make an update about that. Your Honor, we do have a media notice in the file, so I'll get that filed over today.
I'll grant the adjournment. You wanted the adjournment in both cases.
I do, Your Honor.
All right.
I would ask for a week if the court would give it to me. I do want to address bond though. So the bond issue may impact the my request as to when the next court date should be.
So depending on what I do on bond, depends on what she's going to ask for. However, having no bearing on what I'm going to give.
Yes, Your Honor.
Why is everybody trying to trick me today? Go ahead.
Thank you, Your Honor. So Mr. Kraft has been in jail since March 14th. He was arraigned on the first case on March 16th. And the second case, he was arraigned on March 20th. Now, the bond form stated that he was on bond when the second case arose, but that's actually not accurate because it was a delayed authorization. So he has been in jail since March 14th. He's not been released, correct? And so the first case, he was arraigned on the 16th. The second case, he wasn't arraigned until the 20th, but the alleged offense date back to March 11th. I do want to note that both of the individual girls in these cases are girls that Mr. Kraft has had prior relationships with, one of whom is his child's mother, and another is ex-girlfriend. I do want to note that in the case ending in 0324, he is charged with multiple charges, including larcenies of firearms, but the police report verifies those firearms were not actually registered to the complaining witness, Stacia. She was not actually the owner of the firearms, even though he is charged with theft of her firearms. So that is, I think, a huge issue. The other issue I wanted to bring up is he is charged with 2 counts of misdemeanor domestic violence, not felonious assault in that case, one of which is for an alleged threat and one of which is for an alleged battery. And then, of course, the resisting and obstructing. I do want to note that the very first thing in the police report regarding the complaining witness's statement is an accusation of Elijah messaging his ex-girlfriend. And I think that's what this case is clearly about in terms of the jealousy, in terms of Mr. Kraft's relationships with both women and specifically the messages that day. I do want to note Mr. Kraft is a Marine Corps veteran who has been deployed twice to serve our country in Afghanistan. He has no criminal history, no convictions. His mother, Ms. Sonia Kraft, is here to support him. She has verified that he can stay with her in Southfield. She works from home. She'd be able to give him transportation to court. He could be on a tether if that would provide further assurance. Again, he's had no bond violations because he's been in jail since. And his stepfather is here as well to support him. So I would ask if this court would reduce his bond, specifically in the 0324 case, given all of those updates, which I think are relatively new since his reign.
Response.
Your Honor, if you would object to any modification of bond. In the first case, the defendant was at one of the victim's friend's house. An argument began. He went to a back room, was heard racking a gun, came back, pointed the gun at the victim while she was holding her infant daughter, and he then removed the magazine to prove to her that the gun was loaded. This was captured on an audio recording, their argument. And in the audio recording, it stated that he could be heard saying, if the police show up, I'm shooting her in the head. And then in the other case, it was another argument between him and a different victim, his girlfriend. He grabbed her arm, pulled her into a different room. The argument continued, and he told her, if you keep raising your voice, I'm going to slap the shit out of you. He then slammed her onto a bed and was kneeling over her and said if she hit him, he would F her up. And then in that case, she had 3 missing pistols and they were found in his car in his suitcase. I have extreme concerns for not only the victim in domestic violence case safety, but the other person's safety in the other case, who was just a friend. He pointed a gun at while she was holding her child. He does have a previous dismissed unlawful imprisonment FA and DV with the same victim on the DV case that was dismissed because she failed to appear. However, she is on board in this case. And I have extreme concerns for their safety given the allegations.
Anything else?
Your Honor, I just want to note that Mr. Kraft does adamantly deny the allegations. He has consistently been asking for a polygraph. We do have a potential witness who we are investigating further, but as to the claim witnesses, credibility in terms of admitting that she didn't tell the truth about the allegations. Obviously, he is proven innocent of the allegations at this stage. Obviously, they are very concerning allegations, but the question is, are there bond conditions that can be set to ensure her safety as well as the community safety pending trial in this case? And I would argue there are conditions. So a GPS tether, no contact, which again, he's had he's given the court no reason to believe. And sorry, let me rephrase. He's given the court every reason to believe that he can and would abide by a no contact order. I mean, he's a Marine Corps veteran. He knows the rules. He knows how to follow them. And a GPS tether, no contact order.
And also how to handle a firearm and never pointed at anybody.
Yes, Your Honor.
Okay, just checking.
Yeah.
Go ahead.
So we would ask for a reduction bond in this.
Motion for bond reduction is denied. I will, however, set his probable cause conference out to April 3rd rather than 2 weeks.
Thank you, Your Honor.
Bond will continue. Thank you.
Okay, I wanted to let that play out before we switched, but Judge Fleischer came online a few minutes ago. So, Mark Mack, you get your wish. Here's your favorite.
Do you have the ability to hire a lawyer, Mr. Rosas? Sorry?
Say that again?
Do you have the ability to hire a lawyer?
Can I get an appointed one?
You have to qualify. We don't give them like it's candy on Halloween. You have to actually qualify. So what I can do is I can have Deputy Miranda give you an application. I need to know everything about you. How much money you make a month, how much money you have in the bank, what kind of car you drive. Fill it out, put everything on there, and then I'll take a look to see if you do, then I'll give you a lawyer. I'll have you go with Deputy Miranda now. I'll have you sign a receipt. Victoria will have you take a seat. Do not leave until you sign our bond conditions. Please.
Go ahead and sign for your reset. All right, Judge, next is page 8.
All.
So
Come on
do you
up.
mind filing those conditions, please? No contact, no weapons, no going within 1,000 feet. You say Hall?
Yes, Judge. Page 8.
Okay. Good morning, Ms. Hall.
Good morning.
Ma'am, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Oh, you're also charged with evading arrest in a motor vehicle. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 19th, 2025, an officer observed a vehicle on Northwest Freeway in Harris County, Texas. The defendant was stopped at a red light when the officer was stopped at a red light when the officer's traffic signal changed to green. The officer began to go through the intersection and observed a vehicle at a high rate of speed disregard a solid red light. A traffic stop was initiated. The defendant refused to stop and continued to accelerate from units to actively evade and lose units. The defendant ran a red light and made a left turn, then traveled the wrong way through a U-turn, then continued down the street at a high rate of speed. The officers continued to pursue the defendant with emergency equipment activated at speeds over 100 miles per hour. The defendant continued to accelerate through multiple red lights, turned her headlights off and drove in circles under the highway and drove the wrong way on the service road while attempting to evade from the officers. The pursuit came to an end when the defendant turned onto a dead-end road. The defendant tried to go around the officer's vehicle and struck the front end of the patrol vehicle. The defendant evaded for approximately 5 to 4 miles. A loaded handgun was found in the glove box of her vehicle.
Paul, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run her license, see if she has a license, please?
Yes, Judge.
I'm ordering you as a condition of your bond not to drive maniacally again. If I find that you drive like this, I'm going to put you in jail the first thing, and then I will take your ability to drive away from you permanently while this case is open. Do you understand?
Yes, ma'am.
I am ordering you not to be in possession of any weapons.
Her driver's license is eligible.
Okay. Do you have the ability to hire a lawyer, ma'am?
I have a court appointed already. I met with her Monday when I came to court.
That may be in your felony case, but just because you have one in a felony case doesn't mean that you have one here.
Okay, may I apply for one?
Okay, I'll give Deputy Miranda, I'll give you an application. I'm gonna have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we generate your bond conditions. Do not leave until you sign them,
Yes, sir.
please. So no driving without a valid license and liability insurance, and then no weapons.
Real quick while he's between things, B. Davis, I agree with you about walking away from the judge while they're still talking. This kind of goes to that respect thing that we've talked about on a couple of different streams now. And again, I mentioned yesterday, I don't know if it's just a generational gap that I have with people or what, but I don't understand it. You know, I've always tried to have respect for especially those who have some agency over me, you know, those who have the ability to somewhat control what's going to happen to me in the future. I think respect matters. I wish we'd get it back. Let's get back to Judge.
Of prostitution, you're facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Officer, as part of a proactive prostitution investigation, was driving around the 32nd 100th block of Tidwell Road. The officer rolled down his window near the defendant and the defendant approached. The defendant offered and agreed to engage in deviant sexual conduct in the form of performing oral sex for a fee of $100.
Okay. Ms. Perez, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you not to engage in like behavior. Otherwise, I will revoke your bond and put you in jail. You understand, ma'am? Do you need a lawyer? Can we provide you a lawyer?
Yes, please.
Okay, I need you to fill out an application. Deputy Etchigoin is going to give you an application. I need you to fill it out for me. I'll have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box while we find you someone. Do not leave until you sign their bond conditions. Okay.
Go ahead and sign, please. All right, Judge, next is page
Aye, aye,
23.
aye.
Walker, come on up.
You're Mr. Walker. Sir, Detrick Walker.
Yes, sir.
Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you can afford one. One will be appointed to you, sir.
All right. On Wednesday, March 19th, 2025, officers were dispatched to a call for service at 10219 Rolston Lane in Harris County, Texas, regarding disturbance. Upon the arrival, the officer spoke to the complainant. The complainant and the defendant had been roommates since January of this year, and the complainant stated that her boyfriend, the defendant's brother, were arguing about his friend being in their house as they were in the bedroom. All of a sudden, the defendant walked into her room and started talking about rent money. The complainant stated that the defendant started getting in her face, but she was backed away because she was afraid that the defendant would hit her. The defendant ended up grabbing the right side of her jeans and pulling her off the bed and dropped her to the ground, causing pain on her back. The complainant stated the defendant threatened her, stating, "I will break your jaw and make you call 911. The defendant stated her boyfriend and her friend separated to prevent a further altercation and that she wanted to press charges.
Mr. Walker, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this person. Do you understand?
Yes, sir.
I'm also ordering you not to be in possession of weapons. A protective order has been issued in this case. You need to get to know it. If you do something to violate this protective order, the state can and probably will file additional charges against you. It's one of the worst cases as you can pick up a violation of protective order. Do you understand?
Yes, sir.
I will protect my county at all costs. I don't care who you are. I don't care what you are. I will put you in jail and make your bond sky high. You become a problem and you endanger my community. Do you understand?
Yes, sir.
Do you have the ability to hire lawyers, sir?
Yes, sir.
Okay, we're going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria, sign and reset. I'll then have you take a seat in the jury box. We'll get your bond conditions, we'll have you sign it, and then you'll be free to go. Please.
It's the last one.
Okay. Ready? So can you file no contact?
Yes, sir.
I have an off docket bond I need to approach on. It is 2503529, last name Broussard. And if I could politely ask you to kill the live stream, because there'll be a lot of HIPAA information.
I'm so sorry.
It's okay.
By pleading no contest, you're giving.
Okie dokie, back to Judge Simpson. We'll keep an eye for when he comes back.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 259016. Any objection to the court having reviewed that report? Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule?
Yes, Your Honor. Not satisfied.
Court will accept the defendant's pleas of no contest to counts 5 and 6. Counts 1 through 4 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
April 21st, 10 a.m. before Judge Washington.
April 21st, 2025, 10 a.m. before Judge Washington. Bond will continue.
Your Honor, may I
Briefly.
Thank you, Your Honor. Last time Mr. Jones was the court was remanded on a positive ETG test. Prior to that, he returned 2 negative ETG tests. And at the time he returned that positive ETG test, he was referred to community correctional outpatient. My understanding is he was forthright about that failed test with supervision agent with the court. This is his first interaction with the criminal justice system. I think after the court reviewed the police report, the court would know that this case is really about intoxication. With the people agreeing with 4A, we're asking the court to consider reinstating his bond so that he can kind of show that he's a good candidate for that purpose.
First round.
Your Honor, we'll leave it in the discretion of the court.
Well, how am I gonna stop him from drinking?
Your Honor, I think he's gonna.
Because that's where all the problems flow.
Won't be no issue.
You kind of said that to us before, right? You really never said that? So when we told you no alcohol, you thought it was gonna be an issue?
No, just said it won't be an issue. I can guarantee you that.
Your Honor, if the court considers our request, I think Mr. Jones will immediately get himself to treatment. I think that's what he needs. That and some kind of support group to just either. Whereas I know that the drinking incident this time, my client tells me it was prompted by him being separated from his family support system. If he were released from custody, he could be away from the complaining witness in this matter, staying with his sister. She's responsible community. She works at a local nonprofit. She'll keep an eye on him and ensure he's not drinking or violating public justice.
Reinstate his previous bond conditions. But he's to report to community corrections for placement on a scram tether. Need an order.
Prior to.
Yes. Thank you.
Thank you.
Okay, I wanted to let that play out before I got to the chat. So, Mark Mack asks, when a judge finds probable cause and the case goes to trial, would he be the judge in that trial? B. Davis said yes is the short answer. Yes is the short answer, but with provision. First off, it kind of depends on what court we're talking about. So in the courts at law, like Judge Fleischer's in Texas, if there's a case there, that case will tend to stay with them throughout the process, unless for some reason along the way the judge is forced to recuse himself, in which case it would move to another court. Now, if we look in the case of Judge Simpson, it's not always that cut and dry. A lot of matters that are in front of him. For example, there was a matter in front of him that we did a video on a couple of weeks ago where somebody had, I think it was 62 charges of child abuse in a certain not nice way that I'm not going to say on YouTube. But he did the probable cause for that, and he read out the full indictment, but then that was bound over to a circuit court judge because of the nature of the charges. So sometimes the lower courts, like Judge Simpson, will hear probable cause, preliminary exam and stuff, and then it's bound over to a higher court. So it's a little bit complicated. Again, kind of depends on which court you're in, what the charges are, that sort of thing. So long answer to a short question, I suppose. Let's go back to Judge Fleischer because he is back online.
Okay.
252-1765.
252.
1765. It's on for 4-1.
Right, Judge. It is off docket. If you've got time, Judge, I can wait till the end of docket. I wanted to.
No, tell me.
I wanted to see if you.
What do you need?
Yes, Judge. So I filed a motion for continuance of that trial setting, Judge. It is like slightly a personal, familial situation. If you don't mind reviewing it, but otherwise, I have been in touch with the state on it. And I could come by, Judge, if I need to in person.
I see your motion, Mr. Bias, but I'm gonna counsel you on this, though. You only get one. I'm not gonna give you another one. You know?
Oh, yes, sir.
I will grant your motion now, but if you come back, and it doesn't matter if it's the same thing, I'm not gonna do this again, though. You get
No, I
one,
understand, Judge.
okay?
Yes, sir.
So we're set for trial April 1st, which is next Tuesday. So how about May 6th?
Yes, sir.
Is that okay?
Yes, sir.
What about you guys? Well, you're not gonna be here, I guess. Just make sure you put it in the notes so that you guys get everything subpoenaed properly and done, you know?
Absolutely.
Hey, Blaze, so we have a trial setting on Perez for Tuesday.
Yes.
I-
I spoke with counsel.
I'm gonna grant it. I'm gonna set it for May 6th, so just be ready with motions and stuff, you know, because that's past it.
And, you know, I was gonna email it before then too, and see. what we
Okay.
do.
All right, we got you.
Thank you, Judge. Thank you, Steve. Appreciate it, guys.
Sorry.
Well, there's a break in the action there. Let's jump back to Judge Simpson because his court's been hopping all morning. So let's follow along with him for a little bit.
Examination in person, April 8th, 2025, 9 a.m. That's before Judge Valvo. Briefly.
Mr. Chairman, my client is going to be asking for a venue I found in this case. This incident 5 years ago. He's already spent 13 days in jail. He's a lifelong resident of Miami. He lives here locally at the Huron Heights. He's hoping to not lose his Section 8 housing. He's got a job waiting for him at the Bellflower restaurant. We just asked that he be given a PR bond. I know he has another bond at 1882. He's hoping to come to resolution of that case.
So he's being held on another matter? He failed to appear on this matter, which is why he has the one that he has.
Understood, Your Honor. This was not properly received. So I understood.
Notice was not properly received. What's that mean?
I don't think that he was aware of exactly when the date time.
So he wasn't told? Is that what he was to relate to me?
He was homeless at that time.
But he wasn't told when his court date was?
Sorry,
He wasn't told when his court date was?
he was homeless, so I'm not sure if he received.
Your Honor,
Yes.
I'll just, add for the record that, I actually arraigned Mr. Page on this case and on November 17th of 2023, where he was arraigned for previously failing to appear for 2 days on this matter. So I can appreciate that he might not have gotten notice prior to that, but he certainly knew then when he was in custody, given that date. But he also
That's what I was getting at. He was told the court date. And he didn't appear. Motion for bond reduction denied, bond will continue. Thank you. Court calls case, People versus Thomas Lee Ellis.
There's a date time set for consistency, requesting negotiations.
Is he on a tether or sober link? What was the alleged BAC in this matter?
One moment. This case, it looks like, it was 0.13.
With priors. Hey, community corrections, sorry. All right. What did you want to do on this case? Probable cause conference will be adjourned April 17th, 2025, 9 a.m. Or as your invite indicates, this bond will continue with the added condition defendants to report to the Department of Community Corrections for placement on a scram tether.
Yeah, I have some.
Okay, that's what I was asking. He's on testing. You already have one. Okay, that's what I thought. Okay. Thank you. Courthouse case, People versus Jacob Potter.
And I said, on behalf of you.
Yeah. Is that who they have?
Robert, President, am I right? State your name for the record.
Jacob Alexander Potter.
Thank you.
This time we're going to be respectfully requesting the sentence for a preliminary exam.
All discovery is complete.
My knowledge.
People have their witnesses available the 8th.
We'll do our best, Your Honor.
Preliminary examination in person, April 8th, 2025, 9 a.m. That's before judge.
Can I address bond briefly?
You may.
My client is going to be asking for a PR bond. Has a place in Belleville where he's staying with a friend over on Rustic Drive. He's going to want to tether if the court deems that necessary. He just wants to get back to his job. He works at public disposal. So 50 hours a week there. He wants to get back to his job. So
Yes.
Your Honor, I was also going to ask the court to address bond, as he has made 52 calls to the victim from his pin since arraignment. In these calls, he says, "You gotta go to the prosecutor's office and tell them it's not written down right, that I live there too. I damaged the door, they're making it look like I just entered the place, I've never been there before, and that I'm your ex-boyfriend." He also says, "Go to the prosecutor's office and speak on our behalf, whatever, I can't talk to you." He also says, "This is a serious issue, I don't know if you can help, I don't know if the prosecutor tomorrow or anything, I don't know. You need to leave your number out of anything you may sign, you know what I mean? If you, or the prosecutor or anything, leave your phone number out of anything that you might sign, that way they can't link you to my call history." And then he also asks her to get on the Text Now app they have in the jail, because we can't see that, and that's why he wants to keep communicating with her. So I have extreme concerns that he can't follow court orders and object to any modification.
I understand your right. We spoke to him. No contact. He understands that there needs no contact period. He just wanted to somehow give information to the court that he lives at the address. Questions. But
He wanted to get that communicated to the person that does live at the address? That makes no sense.
I will just add that when he was at that address, he kicked the door open and entered the house without permission, and he began throwing her items against the wall and was intoxicated. So I have extreme concerns of him even going anything near that.
Defendant's phone privileges are revoked. Defendant's motion for bond reduction is denied. Bond will continue, but his privileges are revoked.
understood, Your Honor.
Thank you.
So real quick, while we're between cases here, I wanted to address a couple things from the chat. First, Mark Mack is asking about public defender versus a paid attorney. B. Davis says, I've seen many public defenders on the channel knock it all. I've also seen pay lawyers not do so well. That's very true. I want to bring up something that I heard from Judge Wolf on this matter a few weeks ago when I was listening to one of his dockets. He had mentioned that in his opinion, the public defenders actually have more trial experience than the paid attorneys do because of the number of cases that they see and the amount of things they need to do, which was an interesting perspective. So he argued that you might be better off with a public defender. I think it personally matters on where you are, as Springwell just put in the chat. Comes down to the attorney. I would tend to agree with that. There's some really good ones out there. One of my favorites to watch is Shreya. She was the one yesterday who was representing the woman who had the newborn, and was having issues being allowed to breastfeed while she was in custody. She's a bulldog. I mean, she just attacks from every angle, and Judge Fleischer's got several of those types of people in his courtroom. Judge Wolf does as well. Some other courts I watch, it seems like they just want to move people through like they're cattle. So I think it really kind of depends. Also, I wanted to address B. Davis. We were talking about studying the law, and it just led me to quick share this story, and I hope you will all allow me to indulge here a moment. But I've been asked several times by a bunch of different people why it is that I started this channel back in October, and I've never actually given that story. So I'm going to give that story real quick. We've done different channels on YouTube. We have different channels on YouTube, but I watch a lot of YouTube, especially when I'm working at the other businesses that we run here. And all of a sudden my feed started showing me a lot of courtroom stuff, and I found it real interesting. But I also looked at it, and no shade on other channels, but I felt like I could do it different. So I just decided one day I'm going to give it a go. So as a quiet side project, I started this channel, and within like 3 days we had like 500 subs. So then I went to Mrs. The Courtroom Files and I said, I started this thing, take a look at it and tell me what you think of what I've been able to do in like 72 hours. And she just looks at me and goes, oh my. And we decided that this was really a special place to be. It's an interesting topic. I enjoy covering it. She enjoys working with it as well, though she does it off camera, at least for now. And it's been a lot of fun. This has been the most fun that we've had on anything that we've done on YouTube because of the amount of interaction that we have, the amount of learning that goes on. Interestingly enough, this is also the most hate that I get out of anything that I've ever done on YouTube. Only 3 death threats yesterday, so that wasn't so bad. And I'm not kidding. I get them every day. I don't know why, but I do. But it's been a lot of fun. And it's interesting because I stumbled into this. This wasn't anything that I ever set out as like, you know what, in late 2024, I'm going to start a courtroom channel. Nope, had no idea. It was YouTube telling me, hey, you might like this stuff, and then me liking this stuff, but then looking at it and going, I could do it different. I want to try to do it a little bit different. And that's what we've tried to do here. And I hope you all appreciate that. Thanks for indulging me. I just wanted to share that story because I'd never shared it publicly before. Let's go to Judge Fleischer.
DWI PTI application, and we're still waiting for a decision from Judge Guys.
Everything is in, Judge.
Okay. Let's set it off another week. And then if they don't have a decision in a week, I'll send an email, say, hey, what's going on? And then we'll waive it.
Exactly.
Yes. Don't worry about it.
So can I approach your Zoom and can my person?
That's what we have.
Thank you, Judge. May I be excused, sir? Thank you. Thank you.
Okay.
We got it.
Morning, Counsel. You ready?
Yeah.
Judge, I'm here on behalf of Christopher Roberts. He had a screening test this morning. The results are negative.
Okay. So where are we headed?
We already have a plea agreement agreed to, Your Honor. We have a plea agreement.
Do you want to do it today, or do you want to wait another setting?
If it's possible to do today, would be wonderful. It'd be great.
Yeah.
Okay.
Have you filed the paperwork?
Not yet, Judge.
Do you mind doing that?
Yeah.
So what we'll do, they'll file the paperwork. We'll call them up to swear.
Okay.
Get it done?
Thank you, sir.
Absolutely.
Thank you. What's your bar number so I can get your example? 241. Yes, please. Yeah. actually want to trade up. So she wants to look at this. So I'm gonna make sure that it's not big. You too. Yeah. Yeah.
There's a bail order for Monday that you signed for Omar said. Not the 5,002, but on the bail order, you put 5,003. Did you change the amount? So it's getting 5,000.
Yeah.
Because you did the 5,002 for both.
Isn't that's the, you know, the thing is because then I noticed that he had missed 3 times, not twice. That's why I did that. What's the cost number real quick?
252
Okay.
0516.
Let's see.
Still has to sign for bond condition.
You can always raise or lower the amount depending. Sure.
One.
I just went off whatever you wrote on the docket, so I just wanted
I requested one, wait on it now.
yeah, impending docs.
Okay, yeah, so I guess let's do the 5,002.
Are ready for activity.
Yep. Okay. Got it.
Thank you.
Sure.
Okay, that is Jefferson. Okay. Okay, hey, I got one of your cards.
Oh, yeah, I get them. The administration is that's just the 280. So now I can do the N14. Box and then the N13. This one doesn't mean that. Yeah, the other. So. You won't have to put that.
Okay, once again, we have a little bit of a lull in Judge Fleischer's court. Judge Simpson is muted. I don't see anybody else that I'd necessarily want to cut to, except maybe go back to Fulton County, Georgia. Always busy there as they work the all-purpose docket. So let's spend a few minutes there.
Probation as a condition of, it's one of the terms of probation. Once you've completed all the conditions, including restitution being paid, and you're up to date with your probation fees, then your probation may be non-reporting. Thank you. And the bench warrant will be dismissed. Thank you. There you go.
Your Honor, can we go to position number 35, Mr. Murphy?
35, yeah, Mr. White's client?
Can I represent myself? I don't have time to wait for the folks.
You're right.
All right, this is Malcolm Murphy, case number 25 CR 001367F. Mr. Murphy, you have been advised of your right to remain silent, and your attorney is presently Mr. Tom White. And how are we proceeding, Mr. White?
Your Honor, this is a negotiated plea.
All right. Mr. Murphy, is that correct? This is a negotiated plea?
Your Honor, if I may, I sent an email, and let me just pull up the date and time that I sent it. I sent an email to the court, including Your Honor, the PDs, and everyone involved in this case on a general email at 5:03 p.m. yesterday, letting them know that based on the injuries to the victim in this case, the state is revoking its offer effective immediately and will be reaching out to the DA's office and requesting an upgrade to aggravated battery. That's based on the information that we received from the victim, who stated he has sustained a fractured shoulder and had to get stitches in his head. So due to that, we immediately revoked the offer prior to acceptance and sent that email to all parties to make them aware.
Well, he accepted about 2:00 yesterday afternoon. So that wasn't prior to acceptance.
Well, the state was not notified that he had accepted the offer. We revoked.
Please off the table, Mr.
acceptance of
White.
that offer.
Mr. White, the case is going to be reset to the next SAP depending on the decision by the DA's office. And if the DA declines, then I'm sure y'all can revisit this plea.
So we can't be heard?
That's what I'm just telling you. What would you like to
So
comment?
the answer is no, we can't be heard on.
No, I didn't say that, Mr. White. I'm just telling you what the court's position is. What would you like to tell me?
Before we're heard.
All right, I'll defer on this ruling until I hear from you.
Okay. Judge, I was at the jail yesterday, and this is how every SAP calendar goes. We do not announce that the plea has been accepted, usually until late in the afternoon, because by the time everybody gets to the jail and has interviewed everybody. But I saw him at about 2:00. I have the jail slip here. He accepted the offer, and the state did not revoke the offer prior to acceptance. And they don't have to be notified of acceptance for it to be accepted. This is straight contract law. There was a meeting of the minds, an offer of acceptance, and he accepted it around 2:00 yesterday. I can't give you the exact time, but it's definitely before the email that went out around 5:00. So we would ask that you hold the state to, and also a little background. Yesterday morning, I emailed Ms. Falk asking when we might expect offers. Got a response very soon afterwards saying, sorry, it's a little longer. We have a new staff. They have to make the offers, and those offers have to be reviewed by senior staff, in essence, is what they were saying. I'm paraphrasing. So the offer was made by someone, then senior staff looked at the offer and said, okay, that's good to go. And then we accepted the offer, and that's where we are here today. So we ask that you hold the state to their offer that was accepted by Mr. Murphy yesterday.
Okay. Ms. Falk?
Your Honor,
Do you have a binding contractual agreement to comply with this contract?
I would disagree because the acceptance was not actually communicated. I understand that he's saying that this is contract, but contract actually requires that acceptance be communicated. So without letting the state know, yes, we have accepted this, which the defense let us know at 12:28 in the morning this morning, we revoked our acceptance at 5:00. 7 hours before we received notice that they were accepting the offer. So therefore, there is no meeting of the minds. The state revoked prior 7 hours before the defense communicated its acceptance.
If this was a civil court and we're dealing with a civil case, and I find that there is an absolute binding contract where there's acceptance, offer acceptance, and there's valid consideration, yeah, I would certainly agree with Mr. White's position. Except in a negotiated or non-negotiated plea, there is no agreement unless the court accepts it. So there's already a conditional agreement, and based on the representation, the base of the alleged injury sustained by the victim, the court is not going to accept any plea until the district attorney's office has had an opportunity to review this and to see whether there are valid grounds for felony charges. If they decline it, the case will be revisited with either the same plea offer or a different plea offer. So, Mr. White, would your client like to arraign the case today, or would you like to be reset for the SAP next April 3rd?
I'll need to speak with him.
All right. Courtroom 2, Mr. White would need to be contacted to speak to Mr. Murphy.
And Your Honor, I would just like to place this on the record just in case there's an issue later on. Under Anderson v. State, which is 352 Georgia Court of Appeals 275, it's an October 15th, 2019 case. A defendant's purported acceptance of any plea offer must be communicated to the prosecuting attorney to constitute acceptance prior to withdrawal. That cites a Sparks v. State case 232 Georgia Court of Appeals 179, which is a 1998 case.
And does it say that if it's accepted and communicated timely, that it's a binding contractual agreement that must be enforced by the court?
Well, in this case, since there was no communication, there is no acceptance, according to the Court of Appeals in this 2019 case.
All right. Thank you. All right. Courtroom 2, next case, please.
Okie dokie. I'm watching 9 different courtrooms at the moment. I'm not super excited by anybody that I'm watching, but I'm always prepared for just such an occasion. So let's hop in the Wayback Machine and let's go look at Judge McNally. This is from a couple of hours ago from a session he had earlier this morning. So let's ride with this for a little bit until some more excitement comes to us live.
Date being on November the 24th. So I set it for sentencing after I took his plea, the violation of the law. I said I wanted to see how he was doing on the other case. I've had that case pulled. Do you know if he completed his, this is 24F243037. Do you know if he completed his community service on that?
Judge, I don't, and moreover, I don't see that file on the document.
I know. I just had this pulled. I'm just asking.
I got it. Okay,
did you do your community service on the operating while impaired in front of me?
Yes, sir. My community service.
I know he did. I know he did 2 days on the A and B file. The one that was under 771. I saw that. You did it for the assault and battery case and the DUI case, both 2 times? Okay. So yes.
So here's the issue. He had the disorderly person. He had it under 771. And then he went out and picked up this drunk driving.
Correct.
And I don't know. All right. Who are you? Who's here on what case? What are you here?
I'm going to fill in for Mr. Donald, Mr. Robinson.
Okay.
And I have Ms. Johnson after.
All right. So I just want to make sure. I took his disorderly case. It was an assault and battery initially. They pled it to disorderly. He was convicted of operating while impaired in this court. That led him to plead guilty on this probation violation. I was awful lenient on the other case. I think it was a light breathalyzer or something. But nonetheless, he has this violation now. Is there anything you'd like to say before I sentence him?
Yes, Judge. I have had an opportunity to counsel advise my client on the disorderly, which was on A and B, I believe, initially. And what we're going to propose to the court is revoke the probation, revoke the 771.1 status. He has 1 day jail, 1 day jail credit, close the file, because if he's got the OWI case. So if the court were inclined to impose any term of incarceration, we would ask that that consideration be given on the new charge with the OWI case. realizing that since.
I didn't really even place him on probation on that.
No, it's a delayed sentence.
Wait a minute. No, on the drunk driving I'm talking about. I sentenced him on that other case.
Okay, Judge.
I sentenced him. No, I did sentence him to 12 months, I believe, probation. I see.
So then my position would stand the same. I would ask.
Hang on one second. I don't think I placed him on probation on that case, did I?
Jessica has a note here that she has him on probation for the other case.
For the drunk driving?
Yep, and then she just put notes in here that his money's paid on this case, his community service is done, and then he has the class scheduled with PRS for March 13th, but he was.
Wait a second, we're getting confused here.
The anger management was not complete on.
Wait a minute. I'm talking about the operating while impaired charge.
She put a note in here, I don't have the specific file for that case, but she put a note in here that she also has an observation for the new case, the OWBI.
I didn't do anything. I didn't order him to attend a class. I ordered him to go.
On this case you did.
Yeah, on the disorder.
I know.
Yeah.
But you're asking.
I'm asking that you revoke the probation on the disorderly case, close the file, strike the 771.1. And on the OWI case, if Your Honor is going to do any imposition of jail, I would ask that it be done on that case, not on the disorderly.
I didn't place him on probation on the drunk driving, I don't believe.
She has no, I can go pull the probation file.
I don't know why I did what I did. It looks like I started to.
We adjourned the sentencing today because I think that you wanted an opportunity to.
We adjourned the sentencing on the probation violation.
Correct.
Which was the disorderly. I wanted to look at the other file. I don't know why I wrote it up like I did. It looks like ultimately I did not place him on probation. And you're asking me to just close out the disorderly, and if I'm going to send him to jail, send him on the drunk driving.
Yes, Judge.
And the drunk driving was still a first offense drunk driving. And I don't believe he's on probation. So what yeah.
I have the file up. Do you want me to explain? It's in probation
Sure.
status because you ordered community service, but it was not put on probation.
Right. And I've got one attached here that says probation 12 months though, is what I'm saying. I did not fill this register out right. I have a feeling that I was going to place him on probation and decided at the last minute that I wasn't going to place him on probation, but I have a order of probation that says 12 months. But then I wrote on the regular register of actions, which tells me that's what I intended to do, which was simply 1 day community service in the victims impact panel. I need to have us go back and look or listen to what happened that day.
I specifically typed not that you did not put him on probation, just community service.
Yeah, I don't think I did either. But I've got an order of probation in here, and you're telling me she thinks he's on probation.
Well, I'm assuming she put that, again, I don't have the file, but she's probably then just monitoring the community service.
That could be, okay. Give me 1 second. Fines, cost of recovery, 2 days jail. Not going to place on probation. I did not place him on probation. I'm gonna write right on top of that order of probation. This was not part of sentence. So basically what I'm left with is a guy who was on probation for disorderly that went out and committed a crime while he was on probation, and he was convicted of operating while impaired. So I'm gonna go ahead and sentence him. I'm gonna first of all listen to anything anybody else has to say. If anybody wants to try to convince me the 771 status should not be revoked, have at it.
No, Your Honor, I think part of the punishment is that the criminal conviction will enter on his public record on the disorderly. So I would just ask that the probation be revoked on that file. And if
I know, you want me to close it. I'm not gonna do
yeah,
that.
just, yes, Judge, please. Well, we got the OWI to work with now, so.
Or no, give me another order of probation. No, we don't, because he's not on probation.
I agree, but we're dealing with the other file now. Whatever you decide is what you decide, but at least the older file is now closed.
What?
The disorder.
No, I'm not closing it. I'm entering the conviction and I'm gonna sentence him on it.
Yes, Judge. Yes, Judge.
All right, now. Let me just make sure, one more thing and I'll be ready to go here. Did he, I think you said this, he has not done or he has done the week, you said he did not do the weekend program yet, right?
He did not, it looks like he was ordered to complete, yeah, the anger management. It's like, they don't have a weekend, it's a one-day thing, but he did not. He was scheduled for March 13th, but he failed to appear.
And Your Honor, I believe the explanation was that he made a good faith effort to register or log in, but there was a technical issue. Okay. And the first day he was actually excused for work and it was rescheduled. So there was something with his inability to log into this program.
All right. But he did his community service on that case, correct?
Correct.
And he paid his fines and costs.
Is that true, Lisa? Did he pay his fines and costs on the disorderly?
The register of actions.
All right. So we no longer need a probation review hearing date. I'm revoking the status. I'm gonna listen to anything else anybody wants to say, and then I'm gonna go ahead and sentence him.
This is your time. You have an opportunity to speak to the court. This is regarding the disorderly file. First. Yes, yes. And you don't have to say anything if you don't want to. He's ready to be sentenced.
You don't have anything you want to say?
No, sir.
6 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance if you change your address, your place of employment. And again, this is a new sentence now. If you change your place of employment or your address, you have to notify probation. You have to report there as directed. No contact with James McGahee. He was the victim on that. You're not to possess firearms or dangerous weapons. You're to attend the anger management weekend. We're not off to a good start today. It stopped recording. We're having problems with the recording.
Testing.
All right, so I don't know where it stops, so I'll repeat this. 6 months probation. You cannot leave the state without the consent of the court or violate a law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. Anger management weekend program. No contact with the victim, James McGahee. You're not to possess firearms or dangerous weapons. You're to serve 3 days on the court work program and pay $35 a day for that, for a total of $105. I'm not going to charge you the victim's rights fee and justice assessment fee since you've already paid that. New fines on this, 100, cost 50, 120 in probation fees. So you have $270 plus the court work program fees, $375 or 90 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that, sir?
Yes, sir.
Now listen, Mr. Robbins, I've seen you a lot. I don't want to see any in here again, okay?
Yes, sir.
Stay out of trouble. You're a likable guy, but you got to use your brains here. Come on.
When you want that paid back?
Can you pay it today? Wait 1 second. Can you pay this today?
375.
No, sir.
When can you pay this?
Probably, like the third week in April, get my rent out the
I'll
way.
just make it, tell you what. I will just make it. And make sure this gets, I'm gonna make it May the 15th, okay?
Yes, sir.
I'm gonna trust that you know, you can pay a little bit as you do, and if you need time, no problem, come talk to me, I'll be glad to give you an extension, okay?
Yes,
Do
sir.
not ignore me, all right?
Yes, sir.
You can either call in, I'll go on Zoom with you, or you come in person on or before the due date, I'll give you an extension. Stay out of trouble now, I don't wanna see you back here, good luck. All right, thank you.
Okay, James Thompson in the chat. Are these things just live streamed for the world to see? America is wild. Well, America might be wild. You can make that argument for pretty much any country. But yes, in the United States, courtrooms are a public place. Now, not every courtroom live streams, but some judges have taken it a step further as far as courts being public and being transparent to putting these out for the world to see. Is there censoring that happens when there's sensitive matters like crimes against children and things like that? Absolutely. So not everything makes its way to the interwebs, but a lot does. And that's kind of what we do here. So let's go back to Judge Simpson. He is unmuted now, so let's see what's going on there.
Calls the case, People versus Justin Fowler.
And then on behalf of people. And I think we have Mr. Fleischer, right?
All right, what are we doing? I do have a plea form. Plea form indicates that the defendant would be pleading to count 3, which is MDOP, malicious destruction of personal property less than 200 in a domestic relationship, as well as domestic violence, second offense, the 1 year. That's the added count 4. Upon a successful no contest plea to those charges, counts 1 and 2 would be dismissed. There's also an agreement, although the court can't bind the sentencing judge to no upfront jail, but there is an agreement to pay full restitution. I'm assuming on all counts.
That's correct, Your Honor.
Sure.
Let's have them sworn.
You solemnly swear to affirm testimony about the truth, all because of the futility. Yes. State your name. Justin Fowler.
All right, so it is this court's understanding that you are going to be pleading guilty or pleading no contest to 2 charges. Is that correct?
Sure.
The first is a stated count 3 of malicious destruction of personal property less than $200 involving a domestic relationship. That is a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. Do you understand that, sir? All right. You're also pleading no contest to the charge of domestic violence, second offense. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court cost. You understand that?
Yes, sir.
You understand what a no contest plea is? 2 things about it I have to make sure that you understand. It first of all means that you're not desirous or wanting to contest these 2 charges. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty to these charges. You understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. All right. Basis for the no contest plea, counsel.
Civil liability.
All right. So, sir, to the charge of malicious destruction of personal property less than $200, how do you plead?
Contest.
To the charge of domestic violence, second offense, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5. Those are the rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on. You understand you're giving up your right to appeal of right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to flee? Anybody threaten you or coerce you?
Sure.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 25-13754. Any objection to the court having reviewed that report?
None of the people, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's no contest pleas to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
April 28th at 10 a.m. Judge Washington.
April 28, 2025, 10 a.m. before Judge Washington. They'll do that. No, you're good. Bond will continue. He's out.
Modification, condition.
Oh, you want me? Oh. I read it.
Work and he travels a lot for work, so I was just asking if this courtroom home confinement.
Response on the people.
They're not looking for court's discretion. I'm just asking if you change them to a hot zone.
What is it? Is his current tether home confinement? Pardon?
Got a hot zone on it.
It should have a hot zone, but pardon?
I'm home to work, so.
So if he can go to work, what are you
He
asking?
has to travel for work in the next few weeks.
To where? Gaylord. You don't even know where that is, do you? You said it like it was a strange city. It's like Mackie has never been to Gaylord, Michigan. Because it's pronounced Gaylord, not. No, it's not two separate words. No, it's okay. We're in Michigan. She's gonna talk about Florida. So I guess the thing is, if under the current order, I don't know if I need to amend it, because under the current order, if he shows proof that he's supposed to be someplace else for employment, he should be able to go.
So what? Can I speak?
Sure.
All right. So
As long as you say Gaylord, not Gaylord. Anyway, go.
Travel, do infrastructure repair, and like the times that I have had to leave, like Saginaw, Flint, they give me extended hours out for those dates. Like my earliest time I think I could have left my house was like 5 in the morning.
They extended your time for you to be able to get there and back.
Exactly. So like Gaylord, it's 4 hours to get there from my house.
I knew that. She didn't.
Well,
Go ahead.
Yeah. So for me to get here all the way to get
No,
there,
I hear you. So here's what you need to do. Get an indication, or I probably prefer to do it this way. Get some proof from your employer that you're to be there.
Your Honor.
Get it?
I believe what Mr. Cowell was trying to say is he travels even more than just Gaylord, Michigan. He goes to other places and it would be a burden for him to always have to, because he doesn't know where he's going as a construction worker and he kind of gets the job on the spot. So I think he's just asking.
Here's what I'll do. I mean, I get it. I get that. But he's going, who is that? That's my train of thought. That was such beautiful music. I almost went to sleep. So when are you going to Galen?
it's not, I don't have it set in stone yet.
It's, I think they have it scheduled for like the middle of April, what I understand, but it's not set in stone yet. It depends on a lot of variables up there. County. So that's kind of why I just wanted to see if I can have the GPS locator, like it's not a problem to have.
Okay, I'll sign an order indicating that as long as defendant provides proof of his, that he's got employment somewhere, defendant may travel to that location.
So every time he wants to do something, he needs to do it.
No, what I'm saying, well, he would have to provide proof to community corrections for his tether purposes, but he doesn't have to come to the court every time. So that, because I get what he's saying, it's going to depend sometimes on what other people are doing, and then all of a sudden, next thing we're called up to go. Get that idea. So what you would need to do, I'm going to give that order that you can go and do it. So they don't have to do extended hours. You'll be able to go. You just have to provide proof to community corrections. Allow you to go work. If you're someplace, why don't you just put this in the order? That if it's over 2 hours travel time, defendant may stay in that location. Okay, put that in the order. That way he doesn't have to worry about that. Okay?
Thank you, Your Honor.
You're welcome.
Regular, like, in and out times to be back home, except for when I'm going out of town. That's kind of.
What? Are you trying to make this more complicated? I'm just.
Your Honor, I think my client is trying to say, does he still have to have a set time and date every time he needs to go to inform probation, or can he just go?
I don't know. No, what I'm saying is, it seems to me they allow him to go to work.
Yes.
Right? And so they have the hours for that. That's what he'd have to abide by. But I get that there are times that he's, the whole notion of going to Saginaw and then having to come back and extend the hours, seems a bit much. It's going to certainly seem a bit much for travel to Galen. Right? But in the interim between now and sentencing, where Judge Washington can address it, I'm trying to set something in place that makes it a little bit easier. I'm not taking all of the guardrails off. I'm making it a little bit easier for him to be able to work.
Oh, yeah, absolutely.
Okay.
I appreciate that. Like I said, I don't have a problem with keeping stuff. It's just the home confinement part, moving around, trying to get to work.
I get you, but there's a reason why that's in place, but we're kind of loosening the parameters of that and allow you to work. Okay. Do you think, Ms. Mackey, you could prepare that order? No, we'll wait. We'll see what it says. I have to send it back, and then next thing I know, I got to review the transcript. It's going to be a mess. All right. Thank you.
Okay, B. Davis, we're talking back and forth in the chat about talking in front of people like the Supreme Court or powerful groups or stuff like that. I have a story that I want to share at some point here, maybe this morning, if you'll all indulge me. But before we get there, Judge Fleischer actually is back in action after pretty much falling asleep in his chair for a while. But he's got one contestant and looks like one stacked behind that. So let's listen in there for a while.
I don't know if there was a mix-up in that where the probation, office was. And I don't know if that may have, so I'm just throwing that out there, that may have been part of it.
What do you think for bond?
Judge, we depose any PR bond, we'd ask for a security of any amount at your discretion.
Okay, so what I'll do is I'll set bond at $1,500 surety.
Okay.
Okay, I'm not going to grant you a PR bond. I think that you're a flight risk and you're on felony probation. Regardless, you've not made the $10,000 bond upstairs. If you're able to make bond, we can come back and talk. But if you do, it's extremely important that you maintain contact with the lawyer here.
Yes, sir.
Because if you don't, another warrant will issue here and it's just going to balloon and just get out of control. Okay. It looks like you have felony court on the 9th
Yes.
of next month. So what we can do is we can set you on the 10th, the following day, to see what happens there. We can't set you the same day, but we'll set you for the day after, and then we'll figure out how to go forward at that time. Oh,
I can get on in the morning, Zoom, Your Honor, on the 10th.
Are you sure?
Yeah, it's fine.
Okay, then, okay, so set it for the 10th and he can zoom in at that point
Okay.
for this case. And then, so I'll set bond at $1,500. Okay, man, good luck.
But yeah, she has a friend that might be making bond. She doesn't know yet. So if that plays out, obviously she's gonna pop up here before.
Just come back and we can talk.
Okay,
you
thank
know?
you.
She needs to sign conditions, please.
Step back to the middle.
Shreya, you ready? Oh, I'm sorry, Ms. Strong.
Morning, Judge Fleischer.
Hi.
Yes, we're gonna be doing a plea for Victoria Ellis.
All right, so good morning, Mr. Ellis. Sir, you're charged with 2 cases with us. You're charged with evading arrest. You're also charged with unlawful carrying of a weapon. Looks like you've worked out an agreement where they're offering you 120 days on the evading with credit for the 43 days that you've done, and they're going to dismiss the gun case. I'm assuming that's what's gonna, right?
Correct, Judge.
Is this how you understand the agreement?
Yes, ma'am.
You need to understand that as part of this agreement, also forfeiture of the weapon will be done as well. You're not gonna get the weapon back.
Yes, ma'am.
You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, it will go on your record. It will be there forever. You need to understand, Mr. Ellis, that this case, the evading case, this is an enhanceable offense. What that means is that if you ever run from the cops again, they're going to charge you with a felony offense. Do you understand?
Yes, ma'am.
And the felony that you just pled to upstairs, they can use that to enhance your punishment even more. Perhaps they can hit you with a 3rd degree and you could be looking at 2 or 10 of the penitentiary. Just stand, just straighten up, fly right, do something with your life. Stop becoming a statistic, man. It's not hard. If you ever need anything, come back. We can give you whatever you need. Cell phone, a tablet, a job, whatever you need. All you got to do is come back and ask. Do you understand? Stop picking up convictions. You're just killing yourself. How do you plead to the offense? Guilty or not guilty?
Yes.
I'm going to find you guilty. I'm going to sentence you to it. Good luck, Mr. Ellis. Thank you, Mr.
I just filed that dismissal dash. Dismissal.
Did you put forfeiture of the weapon? Please, yeah. Shreya.
Sorry.
Hi.
I believe they're bringing out the brew for a waiver. Here it is. I'm so sorry.
Alyssa Hall?
Hey, you want to come talk to me while we're waiting?
Okay. Good morning.
Hi.
Here on Mr. Jermaine Mallard.
Said Mallard?
Yes, sir. I wanted to approach about his bond conditions to see if we can get those amended. Currently, he's required to do the random drug and alcohol test. He has a GPS monitoring with the curfew from 9 to 6, and he has a scram device. I wanted to see if he could get the GPS monitor removed and have the curfew removed. He does work. His work hours are from 6 a.m. to 6 p.m., sometimes 8 p.m., depending on the day. But he also needs time to travel to and from work. He also supports 4 kids.
Time do you want?
I'm sorry.
What time do you want again?
I was asking for it to be removed.
I mean, it's a DWI second. It's got. I need to do a deeper dive. So if you want to give me a second, we can talk further, but I've got a waiver real quick. Let me help him out and then I can do a deeper dive. I put it on there for a reason. It's only been, not even 2 weeks. So let me do a deeper dive to see why, because I don't remember.
Yes, sir.
Good morning, Mr. McGrew. Come on up. So it looks like you're wanted out of Lafayette, Louisiana for a theft. Is that right? Are you waiving formal extradition, sir?
I am.
Okay, man. Thanks. Wish you the best of luck. We got you here. Thanks. Nathan. Hi, Nathan. You ready?
Just a brief update because we're going to be back on Monday. I wanted you to afford your big brain the opportunity to start thinking about how this might go and not spring it on you Monday.
Okay.
Okay. So since our meeting yesterday, I've opened up a line of communication with Judge Geis and everybody else, like you asked me to do, about whether or not a pretrial intervention. We have exchanged emails back and
amenable.
They asked a couple of more questions to me, which I don't know the answer of, and frankly, they have a better means of getting the information than I do, and I made the very specific personnel who could answer their question for them since I was in that position for a long time.
So smart.
But anyway, TRAS is, I think, been completed face-to-face. It has not been generated in terms of form.
Yeah.
What I understand it to be is what we all thought it was going to be, which is residential. And I think we all think that that's best for her, frankly.
Great.
We just don't know what the state's position on PTI versus probation, whatever. I think either way, we're going to resolve it on Monday anyway.
Okay. Well, let's.
Well, I want to get her on the wait list for the bed because that's going to be 2 weeks.
And I can't do that until she's on probation.
Correct. Or there's some form of supervisory order from the court. That's the issue.
Because then it
Can you
doesn't sound-
expedite a bed?
I can try to expedite a bit, but.
That's possible.
Yeah, that's after the.
I honestly don't think it's necessarily bad for her. Ultimately, if she's gonna get this straight, to wait 2 weeks, I really don't. Because if our goal is to not have her come back, this is her shot pretty much to get it straight. And I think everybody knows that. Oh, she's detoxing.
Thing is that she's got to get over that. I'll tell you, that dope sick sucks.
There's a lot going on there too. It's not just one thing. It's a whole bunch of stuff. Yeah.
This is the best thing, really is.
I do ultimately think that that's correct.
The nice thing about this, though, also is that there is aftercare, right? So there's aftercare when she's done.
Well, there'll be IOP, SOP, and more after the treatment.
Yes, I would like, when you do talk to her, let her know that however this ends up, whether it's in a PTI, whether it's regular probation, if she fails in the aftercare, right back into the same thing, it's going to happen. It will happen until it takes.
Well, you are controlling things one way or the other moving forward, and she should be she should be very clear about how it's transpired in the last week. She should be. Okay.
Thanks.
I just wanted to give an update so the Monday it's not blindsiding you with a ton of info.
However, and I think that, the intervention is just such a sweet carrot to dangle. So I mean,
I think so too.
I don't have a dog in it, but
I think so too.
We'll see.
Okay.
Okay.
Thank you, Judge.
Thanks, Fred. All right, you ready? I'm going to need you, please. I don't, so did you get the cause number? Yeah.
Yes, it's actually.
Because they're the same age.
I don't remember anything about the case, so if you don't mind, please.
On March 1st, 2025, at approximately at 11 p.m., the officers were dispatched to a 911 call regarding a motor vehicle stopped on the road with a male in the driver's seat passed out at the 300 block of North 8th Street. in Harris County, Texas. The officer observed the defendant's motor vehicle stopped on the road facing the wrong side, forcing multiple motor vehicles to drive around the defendant. The officer observed the defendant's engine on, with the defendant sitting in the driver's seat, appearing to be sleeping or passed out, with the motor vehicle in drive and the defendant's foot on the brake. The officer observed an open container.
Come up, Mr. Mallard. Just kind of rewind about
Sure.
3 sentences, please, when he's up here.
All right. Officer observed the defendant's motor vehicle stopped on the road facing the wrong side, forcing the motor
Going the wrong way down the street.
stopped on going the wrong way, yes. Forcing multiple motor vehicles to drive around the defendant. The officer observed the defendant's motor vehicle to be on, with the defendant sitting in the driver's seat, appeared to be sleeping or passed out. The motor vehicle was in drive with the defendant's foot on the brake. The officer observed an open container of Bacardi rum, a 750 milliliter bottle, approximately 10% full, sitting in the front right passenger seat. The officer attempted to wake the defendant unsuccessfully, which led to the officers being forced to break the defendant's front right window to get into the motor vehicle due to the doors being locked. The officer placed the motor vehicle in the park, and the defendant was asked to step out, and he immediately fell to the ground. The officer observed slurred speech, red bloodshot eyes, a strong odor of an alcoholic beverage, and poor balance. The defendant refused SFSTs. The defendant advised that he had not consumed any alcohol beverages and wished to speak to ask for his lawyer, and was loudly repeating no comment to all questions. The defendant was read the DIC, and he refused breath, and a blood warrant was signed. The defendant was transported to HCA Southeast ER to obtain the blood, and the defendant
I think I'm good.
Your Honor, this gets into resisting.
Oh, okay.
Which I understand if you
That's okay.
but it is. So the officer the defendant refused to exit the vehicle, even though the officer was asked him multiple times. The officer had to physically guide the defendant out. The defendant stopped walking while walking to the emergency room with the officer, and advised that he wanted to go to the VA hospital. The officer advised the defendant that he had a search warrant, and the defendant refused to move. The officer grabbed the defendant's upper arm and again advised the defendant of the search warrant, and again he refused to move. The officer then advised the defendant that if he had to pull him inside, that he'd face additional charges. Again, the defendant refused to move. The defendant advised he wanted to go to the VA hospital and tried pulling away into the direction to the entrance of the hospital. The defendant went dead weight and laid on the ground outside and refused to move, and screaming at the top of his lungs, "Someone help me." The officers had to be assisted by hospital security and placing the defendant into a wheelchair and transport him to the hospital, and blood was drawn with the assistance of 3 officers holding the defendant down.
Mr. Mallard, do you watch the news?
Yes, sir.
How many people died this weekend due to an alcohol-related collision?
The one that comes to mind, sir, is the softball team. Her mom, her dad passed. It's in critical condition right now. That's the latest one that I did see, sir.
There were at least 3, if not 4, different accidents this weekend where people died. There was in Galveston an entire family that was cut down because of an alcohol-related collision of a person who allegedly just completed a DWI intervention course here, and a couple months later goes out and then decimates an entire family. In this here now, you pled to a DWI not 3 months ago with above a 0.15. Now you hear on another one, there's alcohol allegedly in the car, the wrong way on the street, completely passed out to where. There is a reason why I do things in life. I don't do it just for shites and giggles. I want to protect my community at all cost. And I think that it is an appropriate condition to not have you near the car. Do you understand?
Yes, sir.
All I care about in this short life is protecting my community. And I'm going to try to do it at all costs. I understand that it may be a hardship to you, but sometimes in life, things are learned when they're faced with difficulty. And now I do not want you out in the middle of the night, and I don't want you near a car. Do you understand?
Yes, sir.
Perhaps in some time, because I'm not an a-hole. I try not to be, right? But it's been 2 weeks since you've picked up this deed of rights. I shudder to think, do you have the blood back yet?
No, I did not have to get back yet.
Before anything, even remotely getting near, I want to see some proactivity on your part.
Yes, sir.
But you coming up here and saying, woe is me, goes in one ear, goes out the other ear. I care about my community. That's what I care about. That's what matters most to me. And I'm going to protect it at all costs. You understand?
Yes, sir.
So I am willing to work with you on the hours if you need hours to work, but I don't want you out in the middle of the night. Do you understand?
Yes, sir.
Okay, thanks.
Thank you, Yanni.
Please.
And just to let you know, he has started attending AA meetings. He's been attending for the past couple of weeks every night, virtually. One of the facilities that offer the AA meetings, they do offer it, is it at 10?
It's at 9:30.
At 9:30, but his curfew would need to be extended a little bit more, that too.
You can do it at all times during the day. You can do it remotely. You can do it via Zoom. You can do it online. I don't want you out at night. It's not going to happen. Because then if I let you out at 9:30 at night, well, I need an hour to get back home. And then now it goes to 10:30. I'm not going to do it. Their AA meetings are literally all day, every day. You just have to find it. You have to be creative. That's why we have computers. That's why we have the internets to be able to help you.
Yes, sir.
Thanks.
Thank you, Yanni.
Okay, he's got other people approaching, so we're going to continue to ride with him. But really quick, there are some things that I want to talk about. We'll get to that. Also, I guarantee you by the end of the day, Judge Fleischer professing that he's not an a-hole will be a short on this channel. So be looking out for that. That's a video right there.
I see you. We can bring Ms. Robertson up now. Good morning, Mr. Roberts. Do you mind, is this a true first on Mr. Roberts?
Yes, Judge.
Mr. Roberts, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 180 days in jail to be probated for 18 months. Is this right? You look confused.
No, he's only expecting the probation. He knows that he's not going to have to go to jail.
Right, so it's 180 days in jail. I probate that for 18 months. You will not go to jail as long as you fulfill the conditions in this case. As long as you fulfill conditions and you do everything you're supposed to, you don't test positive. We all do backflips. What goes wrong is when you don't do what you're supposed to do. You pick up a new case.
Sorry, the offer was for 15 months. I think I made a clerical error and wrote 18 months instead.
Is this correct?
Yes.
Okay, so we'll fix
I'm
it.
sorry.
That's not a big deal. Let me ask you this. Was there an accident in this case?
There was, yes, well, he was asleep next to the train track. So yes, he was off of the road and had crashed through the train track.
It was his own
Single
vehicle.
Yeah.
Okay, so there's no restitution to someone else?
Yes, sure.
That's my concern.
Yes.
Okay, because my concern is that if you do something to yourself or your vehicle, I don't care. If you do something to someone else, then I care. Right. So hopefully, lesson learned, right? Hopefully, you don't get to where some people only learn the hard way. They got to hit rock bottom. They don't get it until they go into here, right? You've worked out an agreement. They're offering you a 15-month. You want me to?
I'll figure it out right now.
It's a 15-month probation. You need to understand that this DWI will go on your record. It's going to be there forever. You can never take it off. And this is important because from now on, I don't care if it's a year, 2 years, 10 years, 15 years. If you get pulled over, officers will see that you're a prior DWI. If you smell like alcohol, if you smell like dope, it's probably not going to go well for you. From now on, after today, you're facing a minimum of 30 days in jail for any new cases that you pick up. No more proverbial slaps on the wrist. Do you understand, Mr. Robbins?
Yes, sir.
For you to successfully complete this program, you must first do a TRAS. This is an evaluation to see what conditions you may need. If they assess other conditions, you must fulfill them. It could be supportive outpatient treatment. It could be, intensive outpatient. I don't know, but we have clinicians that will interview you to determine, is this the right type of program for you? What you must do is a DWI education class, 4 victim impact panels, no drugs, no alcohol, and a guardian interlock and a random urinalysis. Is this how you understand the agreement?
Yes, sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So that's why I said, because you give up this right to appeal, once you accept this agreement, there's no turning around. There's no, you know what, I changed my mind. I want to do something else. This isn't Target. You can return it. You understand? The other thing I want you to understand, Mr. Roberts, is that we all make mistakes. The idea is that you learn from the mistake. And the reason I'm telling you this is that DWI is humongous business in Texas. There's a $3,000 surcharge that attaches to you when you pick up a DWI. If you have a 0.15 or above, it's a $4,500 surcharge. If you don't pay it, you do 1 day in jail for every $100 that you owe. Did you ask me to waive this?
Yes, Honor. There's a bit of a confusion because when I was talking to the district attorney's office, they said that they would waive the fine. So is this a different? Yes, sir. I'm sorry. Yes, Your Honor, of course.
And the point that I'm trying to make, David, this is a first offense. We all make mistakes. But if you continue to make mistakes where you're endangering other people's lives, a second DWI, it's a $6,000 surcharge. And a 30-day minimum jail stay. Do you understand?
Yes, sir.
So if you want to get lit, if you want to have 52 shots of tequila, 35 joints, just don't get into a car. It's not hard. After the probation, can't do it now. You understand? So. All right, how do you plead to the offense, sir? Guilty or not guilty? I'm gonna find you guilty. I'm gonna follow the agreement. Can you look for his license to see whether it's suspended or not suspended, please? I'm not gonna suspend your license. I don't know if your license is suspended now, though. We're gonna look it up to see if it is.
It is suspended, Your Honor. It's not illegal.
Okay, so
He needs to just pay a reinstatement fee of $125 for him to.
is there an ALR suspension or no? You're not allowed to drive.
It is an ALR suspension.
When does it run, do you know?
Until June 10th, 2025.
So
We anticipate filing a request for occupational driver's license.
you can't drive now. If you drive, and I don't care what you got to do, I don't care where you got to go, I don't care if there's a burning building, you have to save 50 kittens. Don't drive. If you do, you're in violation of this probation. If you drove here, you cannot drive home. Do you understand? Don't do it. So I'm happy, file it and we can talk, but don't drive until you either get an occupation or get the license back. Do you understand? So because of that, he'll get a portable device. All right. Good luck to you, Mr. Roberts.
Thank you, sir.
Thank you, Mr. Farrar.
Thank you.
Good luck. So you can run.
Jasmine Robertson?
You
want to wait?
Yeah, that's fine. Did you sign the DPS waiver? Hi, yes, of course.
For clarity purposes, for his curfew, are you okay with, having it 9:30 PM to 5 AM? Because he can't leave until 6, but his work starts at 6. So if he's able to leave at
You want-
5, he should be able to make it to work by 6.
It takes him an hour and a half to get to work?
It takes him, let's see. I know for me personally, but I don't.
How long does it take you to get to work?
If I walk, it's an hour walk.
Okay,
There's no buses.
okay, I'll do 5 in the morning. That's fine. Okay, you got it.
9:30 PM,
What is it now?
9 o'clock, sir.
9 o'clock.
I'm okay with 9:30. It's not a big deal.
Thank you, Your
Okay, of course. Rock,
Yes, Your Honor, I'm present.
you ready?
I'm ready when the court's ready, Your Honor.
Okay, she's signing everything now. And if you don't mind signing it as well, huh? Please.
I signed it earlier, Your Honor.
Okay. Ms. Roberson, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. So this was, they applied for PTI and were denied. Is that what?
Yes, Judge.
What was the reason for the denial?
Due to prior criminal history out of state.
Any prior DWIs?
Yes, out of Louisiana.
How many?
One.
What happened on that case?
The,
Took your time, sir? You know?
let me see, Louisiana is tricky in terms of how we can view their criminal history.
Please, please. If she has a prior conviction for DWI, Brock, I'm not doing this. I can't.
From my understanding, Your Honor, it wasn't a DWI, the prior conviction. I think it was something alcohol related, but I don't think it was a DUI or DUI.
I'm having them look.
I mean,
I believe we would have to reach out to the agency out in Louisiana to find out what the disposition that was.
Kayla, do you mind running a PSR on Miss Roberson, please?
Because I can also reach out to, Hazel, I heard that our people see that they have the infection on it.
What does it say there? Does it say?
It says, the container vehicle and operating vehicle while intoxicated, security shields. I don't know this position, but those are, so we can reach out to, shoot there, but I'll get everything. Figure out the information on those cases.
Okay. Brock,
yes, sir.
I need time.
Okay.
You need to
How long do
understand
you,
something, that I take this extremely seriously. And when I have someone who continually picks up DWIs, no more proverbial slaps on the wrist. It's not going to happen. I have the ability to accept or reject a plea bargain agreement. If I reject it, then you will be allowed to withdraw your plea and we can either set up a trial or renegotiate something, but I'm not going to continue to do the same thing in hopes that, well, I hope nothing happens in the future. It's not going to happen. So I guess what we can do is, you want to roll it till Monday, Brock?
she's coming from Dallas. Remember, this is the one that's coming from Dallas, Your Honor. So
Okay, so
I've
I
been
guess
trying
let's,
to keep her coming back and forth because she's been coming almost every week.
So Brock,
So
I didn't know this.
and Judge, we're reaching out to Lafayette Powers right now, seeing the information that we're going to stand out.
Okay, just can you chat me your cell phone? And then
Yes,
I
Your
can
Honor.
reach out to you when we have something.
Sounds good, Your Honor.
Okay, thanks, bud.
Yes, sir. Thank you.
Sorry.
Okay, he stepped away, so this would be that natural break I was looking for. So, indulge me for a little bit, if you would. We're building a little bit of a gathering here on the live show. Again, I think we're in week 3 now. These things take time to build, but we have some regulars. And first, I want to say thank you to all of you who keep tuning in. I appreciate that. The more people who do that, the more we grow this. And this is a totally different project from what we do on the rest of the channel. And I just first want to say that that's appreciated. But part of building this community, in my opinion, is going to be those of you who watch getting to know a little bit about me, and me getting to know a little bit about you. That's how community happens, is learning about each other. So from time to time, I'll tell you a little bit about my background and what I've done and whatnot, and I'd like to hear that from you too. The only thing I will never discuss on this channel is politics, though. This is a political free space. We talk about the law here. Politics is way too divisive. It's not that I don't have my views, and I'm not scared of my views, but this just isn't the forum for it. Find me on another forum if you want to talk about politics. I'm out there for that, but not here. But B. Davis and I were talking in the chat a little while ago about important interactions that you have with people, whether it be job interviews, or we were talking about interactions in front of the Supreme Court, or all of that. So one of the things that your host here has been through is Mrs. The Courtroom and Files and I have worked for about 20 years now on our own. We run our own businesses, we do our own thing, and it's wonderful. But I will tell you, you have to be very self-motivated, because there's nobody telling you that you have to go do something. But before that, we spent a long time in the corporate world, and I spent some of that time working for a large national retailer, and at one point I was running one of their, what was it, 620 stores they had at the time, something like that. And I was brought into a national meeting because I was the only store that figured out how to be profitable on Black Friday. It's very hard to do as a retailer because everything's being sold at a loss, but I figured out how to do it profitably. So anyways, I got invited to the national meeting where all of the store managers, all of the higher ups, everybody was there. It was 1,500 people, I think, something like that. And they wanted me to speak as to how I was able to get that done. And I'd done stuff in front of groups before, but my style is different from a lot of people. And again, B. Davis and I were kind of talking about being prepared and whatnot. My version of preparedness when I speak in front of somebody has nothing to do with writing out notes or a speech or anything like that. I read my material, I make sure I understand it, but I never plan ahead of time what it is I'm going to say. I had no agenda when I started the stream today. I get on and I go. It's a little bit of a different approach. But anyways, my boss also had to make a speech at that gathering. And he had notes and note cards and everything written out, and he's fumbling through it. And he came to me and he's like, well, what are you going to talk about tomorrow? And I told him, well, I'm going to talk about the subject matter, how it is that I'm able to be profitable. Well, don't you have something written out? No. Well, where are your note cards? I'm like, I don't need note cards. Well, how are you going to make a presentation? I'm just going to do it. I just get up there and I talk. These are just people. It doesn't have to be scripted. Well, mine's scripted. Like, well, good for you. I'm glad it works. He was freaking out the whole time. Long story short, he went up and did his presentation and he fumbled his way through it. I went up, did mine. It flowed great. Lots of laughter, lots of good interaction with the audience. It all worked. And then after that, he talked to me and he congratulated me. And he said, yeah, he said, I didn't do well on mine at all. And I told him, I said, I think you over prepared. He was so in his head about things that he couldn't get it done. I guess what I'm trying to say is everybody's got their own style and whatnot, but you have to learn what works for you, and you have to not overthink things. And that's one of the reasons why I think I've always been successful is I know what I am, I know what I'm capable of, but I don't I don't try to go off script of what I am and who I am and what works for me. That's just a little bit about me. I just kind of let things flow, and it's always served me well. So just sharing. Let me know your thoughts in the comments. Looks like Judge has got somebody else back in front of him. We are running long, but I'm content to do that for a little while. So let's go back to Judge.
Yes. Let's see here. The gentleman we sent to go get the evaluation, Mr. Adrian Flores. We sent him to do the TRAS. Can you hear me, Judge?
Yeah.
And then I think during the TRAS, Judge, yesterday, the day before, he started hearing voices. There was some problem and couldn't complete the TRAS.
What was the last name again?
Flores. I've got the number. Well,
Oh,
think it's
he's not on docket today though, Harold, huh?
no, he's off docket. Victoria wanted me to Zoom with you and just talk with about it.
Do you have a cost number?
I have a spin number,
I'll take it.
03
Uh-huh.
01
Uh-huh.
6971.
And I think I think the letter styled it as he was refusing, but I think he was having a problem. I mean, I wasn't there, but just the way she described it, that's kind of what.
It sounds like he was in a psychosis, like he was having hallucinations and preoccupied, just unable to like engage.
Have they not evaluated him for any kind of medication?
We can't give him medication. His competency evaluation came back and he was competent, so we sent him to do the TRAS.
So let's recomp him then, you know? I guess we should have him reevaluated, Harold.
Okay.
You know, I don't know what else we can do. We can ask for a different, you know, someone different to evaluate.
Sir, about there's just a problem.
Are you okay with that?
Oh, that's fine. That's fine because I think
So
I mean maybe
let's put him on for tomorrow. That way we can get the order done, and then I can try to expedite it, so we get it done as quick as possible.
okay. You mean for Monday maybe? It's Friday, right?
Say
No, wait.
again?
Today's Thursday. Today's Thursday. I'm sorry.
Or can you be here tomorrow? Or you want to do Monday?
Tomorrow morning, I'm going to be again here in Fort Bend County, and I've got 5 cases here in Fort Bend County in the morning.
You want to do Monday?
I could zoom in a little later, but I could definitely. Monday's kind of busy. If I could zoom in, Judge, that'd be fine.
Yes, of course.
tomorrow.
Well, that's why we have it, Harold.
Yeah,
Just, you know,
sure.
make it easy. Of course you can.
That'd be great.
You want to do it tomorrow or when?
Sure, that'd be. We could do it tomorrow, but I think he's not in the holdover today.
No, they're on docket Monday. If he files the orders on Friday.
You know, if you do the orders today, file it tomorrow, I can sign it tomorrow and we can try to expedite it. But the main thing is that we need the orders filed. I mean, and we don't need him, theoretically, we don't need him here for you to file the order. You can just file it. And then sign it and we can just set the process going. We really don't even need him here to do it, you know? I just need you to file the order and then I can sign it and we'll reach out to whoever to expedite it.
All right, I'll do that.
So you want to leave it on for Monday and just you file the order tomorrow?
Sure, we can do that.
Okay, done. Just do that.
Yes, sir. All
Okay.
right. Thank you, Judge. My excuse.
Let me know.
You have a good day.
Thanks, you too. Take care.
Thank you, yes, sir.
Okay, you ready? Hi.
Working on CJ Steers.
Okay.
We were here yesterday. He went and took the drug test, came back negative.
Wonderful.
So we would ask the court if the court would be open to amending the deferred conditions to include obtain a valid driver's license and obtain a GED.
Come up, Mr. Spears. Good job testing negative. That's great. Wonderful. I'm happy to acquiesce. That's great. Really. So look, I'm not asking much, man. All we want you to do is things the right way. And when you do, good things happen. Just get your license, get your insurance, and then your high school diploma. That's it. And I'll make it, does he have anything else to do on the probation?
I don't think.
I'll make you a deal. I'll make you a deal. The minute you get your high school diploma and you got that gun class done, I'll cut you loose. You're done. You're off paper. Literally done with everything. Get the high school diploma, do that gun class, you're off. I'll take you off early. The minute you got all that stuff done. Yeah? Good job. Just do things the right way.
When he gets the driver's license, insurance, all specific case, and then.
See that? I mean, you're holding everything in your own hand. You're holding the dismissals and everything. The quicker you do it, the quicker you're out of here. All right? Okay?
All right, thank
Done.
you.
So, I don't know, you want to reset it like 30 days or so? You tell me.
There's enough time.
It's gonna, I don't know how long it'll take, you know?
Can we make it a little bit longer, but if he gets it before, then all to
But
best.
I mean, you're obviously too old to get back into high school, so you're just gonna have to do the GED, equivalency. Just test it, see what you can do, and if you can pass it and they give it to you, money,
Would 60 days be okay with the court? Okay. All right, thank you, Judge. All right, thanks, Rich.
All right, good job, Mr. Spears. Hi, Aaron.
Hey, Judge. May I approach? I've just got an off-docket matter. It's on a case where my client successfully completed DWI-PTI. She had a gun in her car. I've spoken with the state. They don't have any objection to it, so I filed a motion to restore property. Okay.
Going to you or is it going to the client?
It's going to go back to her.
Okay.
Thank you, Judge.
Sure.
I'll just get with the clerks, make sure that they push it through.
Law conditions for right.
I thought I saw him. Oh, no. Hey, on Zambrano, I don't want her talking to her 12-year-old kid. She's in the kids to commit a crime.
Did you want that as part of the?
Yeah.
conditions? Okay, yes, Your Honor.
No? I mean, come on.
Remove the condition.
I mean, I can put it in. Don't worry. I'll put it in.
I think there's only one.
Do you have initials by chance? You have initials?
Initials of the child? Let me.
Thank you very much. Thank you, Judge.
Sure. Done already?
Yes, Judge.
All right. Easy money.
Hey, Judge, do we get clarification on figures? Are we amending the deferred
Yeah.
to add? those
Amending to
items?
add those two things?
Are we dismissing the new case?
No, no. We're waiting for everything to get done, then it kills everything.
Okay, so we're resetting for 60 days.
Okay, so the amendment was still information pending.
Yeah.
Thank you. And you're on good information on this.
So how are we gonna-
Person.
Okay.
It looks like based on the website, it's not on the top there. Yeah, it's not, there's not.
You want to talk to me real quick?
Yes.
Talk.
Well, it's not gonna be quick, so,
It's okay.
okay, so I'm here
When is
on,
it ever quick? Anyway?
I'm here on Miss Gill. She set, for a bond today, and
She in
so
custody?
she is, yes, Your Honor. And she has one pending felony, but she's out on a bond for that one already. She just has no bond set in this case.
I see bond sets. I see the FSGI is at 1,000. Yeah.
Okay. I talked
It
to
must have
the-
just gotten set. I don't know.
Okay, is it a PR bond?
No. It's a
Okay,
short.
okay, then if we could review it today, is that possible?
Absolutely. Do
Okay.
you mind, Deputy Etchigoin, do you need a translator?
No.
Do you mind me bringing up Ms. Gill? Maria?
Felony a PR bond then?
No. Initials for the kid.
Okay.
Initials or something for the kid? Or maybe a first name? Initial. If you.
Just got out report. One second here.
Judge, I don't have initials, I'm sorry.
While we're waiting for them to bring that person out, I've got eyes on 8 other courtrooms at the moment, so 9 in total, and everybody's pretty much winding down or is on lunch already. So we'll ride with Judge Fleischer through this interaction here, and then we'll figure out if we're going to do anything else after that. So let's see what this goes.
All right. Good morning, Miss Gill.
Good morning, Your Honor.
I wanted to bring you out because we're talking about you, and it's only fair that you get to hear what's transpiring since these are your cases.
Yes, sir.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Or, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Road in Harris County, Texas, regarding an FSGI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallaceville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The
So
complainant.
are you telling me that now it was intentional?
The complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck her vehicle. The estimated damage from the complainant was around $4,000, and the defendant stated she didn't stop because she was hungry and colored.
And what?
Colored.
Color.
Yes, Your Honor.
Can you look up to see if she has a valid Texas driver license?
Yes.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt.
After.
Finish.
I'm so
please.
sorry.
Finish.
I'm a commercial driver.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
In this case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally. Because allegedly hungry and covered. So now, this is an affidavit, and I hope that you take it seriously. Because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor.
May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. Has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she is willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what, Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, I mean, really,
don't say anything.
how many people died this weekend on the road because of the reckless and wanton actions? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping me. I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this. Okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children have trauma, okay? And I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point, your actions become your own, right?
You don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
I call out discrimination when I see it on a daily basis, ma'am. I don't care who it is. I don't care what color. If they're a small farm animal, I don't care. I call it when I see it. The only thing, because I don't know them. The way I get to know them is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes, really?
Officer Harris did not read me my rights.
Well, I will let.
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
Yes.
She just brought me to jail.
You guys speak about that. I'll tell you, look, here's what I'm gonna do. I'm gonna leave your bond at $1,000 now. All right? I'm not gonna raise it to 5, but I can't continue to give you a PR bond.
From employment too.
Listen,
Okay.
do not drive. It's the only thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new
Yes,
case
sir. Yes, sir.
and just, all right. Come on. Justin. I didn't want you to leave because I know you've been waiting.
Oh, no. I heard here, his appearance, was required today. We submitted the mitigation packet. I just submitted, and I've been waiting to hear back from Blaze on some things.
22 and 23.
So, all right.
But he said, go ahead. I showed him what we had. He said, go ahead and send that. He's still gonna have the conversation with those guys about the other
So
things.
you haven't sent it back?
No, I've sent it. He should have it. Yep, I sent it to all the appropriate people.
So we'll give you a couple weeks. I'll waive it for the next one because we're just gonna get a response, okay? If he's approved, then
I'll
he's
be
gotta be
in
here. So we can do a
Okay.
TRAS. Okay?
Oh, right.
So if it's not approved by the next 2 weeks and it's still in limbo.
I'll let you know. Okay.
The only reason we'd have him come is so we can start moving, right? So if it's approved, then we need him here so we can do a
Would
TRAS.
you be able to do like a T-Raz that day, like a walk-in?
Yes,
Okay.
we'll send him and do a walkthrough. Well, that's why we have him come so we can just get it done.
Yeah, no, it's a hardship for him.
Pick a day, 2 weeks, and then waive it.
Gotcha.
It's not it's
In limbo.
still pending.
Yep.
If it's no, or if it's yes, then he's gotta be here.
Gotcha.
Okay,
Thank you, Judge.
have fun.
Okay, I've gone almost an hour long, and at some point I should probably pay attention to the other things that make me money, so I'm going to go ahead and call it a day here. But speaking of money, I wanted to make you guys aware of something. Mrs. The Courtroom Files and I are very committed to continuing to grow this community and continuing to build this community, not just through the live show that we've started, but through the other videos that we post. And I wanted to let you all know that last night we made a fairly significant investment into some things to continue to improve what we bring to you and continue to grow this community. Some of the things are behind the scenes, so you won't necessarily see them. Some of the things you will notice because especially when it comes to the educational content that we want to bring to this channel, it's going to allow us to have a higher production value, things like that. But wanted to let you know that we are here for the long term and we're very committed to what we're doing, and your presence definitely is a big part of that, so thank you. Along those lines, on the way out the door, if you would consider smashing the like button if you haven't already, I'd appreciate that. These things continue to teach the algorithm that we should be shown to other people. And along those lines, if you have friends who are interested in courtroom and legal kind of stuff, please do consider sharing this channel with them. That helps us out a lot. All that having been said, we'll be back Friday. Tomorrow's Friday. 10 a.m. Eastern, 7 a.m. Pacific. Thanks so much for joining us. Take care and God bless.